Welcome everyone to today's webinar, What Every Michigander Needs to Know About the Line 5 Pipeline. I'm Casey Cook, staff attorney for Flow Water Advocates, a nonprofit, nonpartisan Great Lakes Law and Policy Center based here in Traverse City, Michigan. I'd like to begin our event today by sharing a water and land acknowledgement. Flow Water Advocates is located on lands historically occupied by the Three Fires Confederacy, the Anishinaabe, Odawa, Ojibwa, and Potawatomi nations. We are grateful to these sovereign nations for sustaining their sacred waters and are humbled to be a partner in protecting the Great Lakes watershed for future generations. We invite all to honor the first guardians of the water we love by incorporating the Anishinaabeg's water ethic and traditional ecological knowledge into our individual and collective relationships with water and in our advocacy. We're thrilled to present this webinar with our partners at Oil and Water Don't Mix campaign. Today, you're part of an amazing live audience of over 700 people who have registered, who care deeply about the Great Lakes, state and tribal sovereignty, energy and water security, and climate change. We are grateful for your time and interest, and we're delighted to be able to reach you through this free webinar, which was supported with a generous gift from the Mackinac Island Community Foundation and the Straits Area Community Foundation. Thank you. Today's webinar is the latest in an ongoing series of Line 5 programming. By connecting you with our outstanding panel of legal and policy experts, we hope you'll come away from today's event more informed and inspired to take action. This webinar is also especially timely, as this week marks the 15th anniversary of the Enbridge oil spill disaster in Marshall, Michigan. Over 1.2 million gallons of heavy tar sands were spilled, and countless lives changed by what the National Transportation Safety Board called pervasive organizational failures at Enbridge. Events like this are important because Enbridge is working overtime and spending big bucks to convince Michiganders that we're dependent on Line 5 and that the tunnel is a done deal. But that just isn't true. The Michigan Department of Environment, Great Lakes, and Energy has yet to approve the permits for the tunnel and is currently taking comments from the public due on August 29th. Later in the webinar, we'll talk more about that and how to write and submit comments and make your voice heard. Meanwhile, there are 3 active lawsuits involving Enbridge and Line 5, cases that strike at the heart of the question of who gets to decide the future of public water rights, state and tribal sovereigns, or a multinational corporation. This is what we're up against. So let's get into it and talk about where we are and where we go from here. Luckily, our path is being charted by many seasoned advocates and experts, a few of whom we have the pleasure of hearing from today. We have a lot of information to share in this jam-packed hour together, so we will not have the opportunity for a formal Q&A session at the end, but we encourage you to submit your questions as they occur to you in the Q&A section. So if it's not in the chat, it's a little box at the bottom with a question mark in the middle, and we'll get to just as many as we can. So during the first segment of our hour here together, we'll hear from our legal experts, Riyaz Kanji, who is the founding member and directing attorney of Kanji and Katzen, representing the Bad River Band of Lake Superior, Chippewa, and the Grand Traverse Band of Ottawa and Chippewa Indians. And Carrie, Seur, who is our legal director here at Flow Water Advocates. They'll talk about recent developments in the Line 5 litigation and how we're thinking about this fight moving forward. Welcome, Carrie and Riyaz. We'll then turn it over to Flow's senior legal advisor and energy expert, Skip Pruss. He's the former energy officer for the state of Michigan under former Governor Jennifer Granholm, and he'll talk about the risks and unanswered questions around the tunnel project and why it's a false solution for Michigan. Thanks so much for being here today, Skip. And finally, we're thrilled to welcome Beth Wallace, Climate and Energy Director at the National Wildlife Federation and co-director of the Great Lakes Business Network. Beth has been working on the front lines of the Enbridge pipeline issue for over a decade, and she'll share concrete, actionable things we all can do to make our voices heard and help get oil out of the Great Lakes. Welcome, Beth. So with that, I'll turn it over to Riyaz to get us started with some updates on the pending litigation. Thanks, Riyaz.
Thank you so much, Casey. A huge thank you to Flow for sponsoring this webinar and all the terrific work that Flow does on the Line 5 battles. And a huge thanks to everyone for joining us today. The fight over Line 5, as you all know, has many ups and downs, and there are sometimes bumps in the road. But the support we receive, the interest in the case, the encouragement is all tremendous wind in our sails, and we so appreciate all of that. On behalf of the lawyers involved in the fight, I want to start with a little bit of an apology. I know how much interest there is in shutting down the threat posed by Line 5 once and forever. I also know how frustrating it must be to see how long our judicial system can take to get us to that place. We are racking our brains and thinking each and every day about how we can be doing things better, how we can be moving the resolution. And I'm sorry that we haven't got there yet, but it is certainly not for lack of effort. I am going to talk about the current legal fights, the fights over the existing pipeline, and then Carrie will talk about the legal battles surrounding the Enbridge's proposed construction of the tunnel under the Mackinac Straits. And with respect to the existing pipelines, I'm going to break down my comments into the discussion of three cases, which I'll march through fairly quickly, but hopefully clearly. The first of those is in the Wisconsin side of this battle. The Bad River Band's fight to cease Enbridge's trespass across its reservation lands. I think many joining this webinar are very familiar with that fight. The band is fighting a heroic battle against a far better resourced opponent, but has been stalwart in its desire to put an end to the operation of the pipeline across its pristine homeland. We filed that suit several years ago, bringing both a trespass and a public nuisance claim. I unfortunately do have absolutely actually nothing in the way of an update from when we did this webinar a year ago, because we are still waiting for a decision from the United States Court of Appeals for the Seventh Circuit. As many of you know, we largely prevailed in the federal district court on many of the key claims. The district court issued an injunction ordering Enbridge to shut down the pipeline by June 16th of next year, June 16th, 2026. Enbridge, of course, appealed to the Seventh Circuit. We had oral argument in that case in February of 2024, February 8th. The United States, at the panel's request, filed a brief in April of last year. We filed responding briefs at the end of April of last year. So we're now 15 months past sort of the conclusion of argument and all briefing, and we still don't have a decision. I would not have predicted that. I'm sure I did not predict that on the webinar last year that we would be waiting quite this long. I will say, though, that there are many cases in the Seventh Circuit that take over a year to get to decision. And this, of course, is a particularly complicated and important case. So we're not so far out of the universe of the normal. The circuit has a special procedure, which no other federal circuit does in the country, where it allows all the judges on the circuit, not just the three-judge panel, to kind of screen and review the proposed opinion before it is issued. So that adds a whole nother stage into the proceedings. That being said, I'm sure the panel is well aware of that June 2026 shutdown date, which is now feeling quite close. And so I would expect that we will see a decision at some point in the near future. Now, obviously, that's going to be an incredibly consequential decision if the court does uphold that injunction deadline. Enbridge is going to have to move fast. I'm sure they will seek review in the Supreme Court. We would resist it, and we'll see where all that happens. But the first things first, we're just hoping and praying for a favorable decision. Then bringing us closer to home, the second case I want to talk about is the proceedings in front of Judge Jamo, Michigan State Trial Court. and that's the Attorney General's case, Attorney General Nestle's case against Enbridge. That's the case that was filed over 6 years ago now. The Attorney General filed it very soon into her first term in office, and it's the case that we all had hoped that by now would have put an end to the operation of the existing pipelines under the straits. But that's the case, which, as many of you know, has been caught up in a lot of litigation hijinks, very frustrating hijinks, which sort of culminated in Enbridge removing the case to federal court after it was well underway. Enbridge missed a 30-day deadline to remove the case to court by about 550 days. But even though it missed that deadline, in a sort of a catastrophic decision, the federal district court judge, Judge Neff, allowed the case to stay in federal court, which cost us a lot of time. We then had good news within the last year where the Sixth Circuit, the Federal Court of Appeals for Michigan, said no, Judge Neff was wrong. Enbridge had blown the deadline. Case belonged back in state court. So back to Judge Jamo it went. And last fall, both parties, the Attorney General and Enbridge, briefed some of the key issues in the case. And then Judge Jamo held a hearing at the end of January on those key issues. And we've been anxiously awaiting a decision since. The two sets of issues that were briefed and argued were, on the Attorney General's side, her claim that under the public trust doctrine, the easement should never have been issued to Enbridge to operate the dual pipelines on the straits, given the salient significance of the straits to the people of Michigan and the risks posed by the pipeline. That's the Attorney General's fundamental claim in the case, that easement was void from the outset. On Enbridge's side, the issues being pressed are that even if that is true, and of course Enbridge argues it's not true, but even if it is true that the Attorney General's claims are precluded by two sources of law. One, the Federal Pipeline Safety Act, which Enbridge argues covers the field, only allows for federal regulation, does not allow the state to have any control over the continued operation of the pipelines in the straits. And if it strikes any of you as somewhat absurd that an agency as ineffective and captured as PHMSA, the Federal Pipeline Safety Agency, would have exclusive dominion over the operation of the pipeline in waters as sacrosanct to the state as the Straits of Mackinac are, you're absolutely right. It's a very sweeping, radical argument, but one that, of course, the Attorney General and our coalition have taken very seriously. The second argument is that the treaty that Canada and the United States signed in 1977 governing cross-border pipelines precludes any action by the state of Michigan, by the tribes. This argument also applies to the Bad River Band. That would impede the flow of oil. A very sweeping interpretation of that treaty, which ignores Article 4 of the treaty that expressly provides that governments can regulate pipelines in the interests, including of environmental safety. But that's the other main issue that's in front of Judge Jamo. As I said, we were all expecting a decision on that. And then last month, we had another thunderbolt where the Enbridge had appealed up to the Supreme Court the question about the removal deadline and whether it had failed to meet the deadline. And on that technical issue, the Supreme Court actually granted certiorari review, which it does in a very small number of cases. And there are two things I want to stress. One, the fact that the Supreme Court is taking this case up, it's not taking up anything having to do with Line 5 itself, its safety, whether the state is in the right or the wrong and trying to shut it down. It only took up this very narrow question about when a case can be removed to federal court, the sort of timing issue. And secondly, the fact that it took that up does not mean that it agrees with Enbridge, that the case should be in federal court. Enbridge had argued that there was a conflict in authority between lower federal courts about how to interpret that provision. And that's the narrow issue that the court is going to resolve. The problem is that could engender further delay in the state court proceedings. Enbridge immediately moved Judge Jamo to stay his hand until the Supreme Court rules, which will not be until next spring or summer. It could be as late as June of next year. The state filed an excellent brief on Friday saying, no, 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 you can proceed. You should proceed to decide at least interim issues in the case, finally get to some decision on the merits, or we're going to lose another year, even if the case is properly in state court. Our coalition of tribes and environmental organizations just is filing a brief today in support of that position. What Judge Jamo does there will be incredibly consequential. And the hope is that he will continue to move forward and issue some decisions on the merits, or we will really lose another year in this fight. Finally, I'll be quick on this one. There are also parallel proceedings in the federal trial court in front of Judge Yonker in Grand Rapids, who's a very smart, excellent judge, where Enbridge, because they love to multiply and confuse and slow down litigation, they filed a parallel federal suit where they are raising their same claims about the 1977 treaty and the Pipeline Safety Act. Judge Yonker has to decide whether he's going to actually get to the merits of those issues. The state is asking him to abstain in deference to the state court proceedings because it's unusual to have two courts deciding the same issues at the same time. He'll need to decide whether he's going to do that. If he doesn't abstain, then we will be getting rulings from the federal court on those issues, as well as potentially from the state court. So while we've had a lot of delay, further delay, and a lot of frustration in the next few months between the Bad River case and the Michigan federal and state court proceedings, we could be receiving some highly consequential decisions. And with that, I will stop and turn it back over to Casey.
Well, thanks so much, Riyaz, for that really excellent summary of a really complex web of litigation going on. I'm going to turn it over now to Carrie to talk about some of the other legal processes that are underway, and then we'll pause for a question or two on the legal update. Over to you, Carrie.
Thank you, Casey. I am so happy to be here with all of you today, and I wanted to echo Riyaz's comments about how much all of us who are working on these issues appreciate the engagement and support we hear from so many people who just genuinely care and keep up with every small development in this saga we've been working on for so many years at this point. Today, my assignment is to brief you on the work Flow Water Advocates, formerly For Love of Water, is doing to protect the Straits of Mackinac and the Great Lakes from the risk of a catastrophic oil spill. In cooperation with many allied organizations, a few of which are represented here today, we have been working through all available legal and advocacy means for nearly a decade to ensure full regulatory review of the proposed tunnel and push harder on efforts to shut down the dual pipelines, despite Enbridge's years of defiance of Michigan's sovereignty. And I've got to add, we are especially pleased to introduce to you Staff Attorney Casey Cook, who's moderating the webinar today. She's greatly expanding our impact on Line 5 proceedings by taking a coordinating role. So a special welcome to Casey. Let's go to the next slide about Flow's appeal of the Michigan Public Service Commission's permit authorizing construction of the Line 5 pipeline. In April, 4 Indigenous tribes and environmental advocates, including Flow Water Advocates, asked the Michigan Supreme Court to overturn a lower court ruling upholding the PSC's approval of a permit for a tunnel to continue pumping crude oil beneath the Straits of Mackinac. We argued that approval of the project violates both the Michigan Constitution and the Michigan Environmental Protection Act. And in separate briefing, Flow argued that the PSC and the lower court failed to meet their obligations to apply the requirements of the public trust doctrine to ensure protection of the public's interest in these natural resources. The Michigan Supreme Court has yet to rule on whether it will hear the appeal. They could at any time. If the appeal goes forward, we'll move quickly into a briefing schedule and likely oral arguments in Lansing that we hope to make available by either audio or video. At the same time as so much court action is happening, we are engaging on permitting at the state and federal level for the tunnel. The state permitting proceedings are currently underway for the tunnel. And I wanted to talk you through some of what's going on and some of the opportunities for public engagement in the next month or so. First, Enbridge's application for a joint water resources permit under Michigan's Natural Resources and Environmental Protection Act was recently deemed administratively complete and ready for review by the Michigan Department of Environment, Great Lakes, and Energy, or EGLE. EGLE had asked several times for more information and further analysis, but we still have a number of concerns about things that haven't yet received the thorough level of analysis, especially engineering review that they require. This permit requires evaluation under Part 303, the Wetlands Protection Act, and Part 325, the Great Lakes Submerged Lands Act, as well as supplemental compliance with the Michigan Environmental Protection Act, or MEPA. EGLE published its public notice on July 16th, 2025, which officially started the agency's formal review of the application. And we will be digging into Enbridge's application materials, the additional information submitted in response to EGLE's requests, all this in the coming few weeks. But we have serious concerns with the scope of this application, the review that's taking place, the materials provided that have already been identified. We're concerned about failure to incorporate the tunneling work itself in the application for a permit under the Great Lakes Submerged Lands Act, and the application's apparent failure to provide information necessary to conduct proper public interest and alternatives analysis as required under the Wetlands Protection Act. There are several opportunities for you to engage as a concerned member of the public. They include attending the public information session on August 12th at 6 p.m. Eastern. You can ask questions, find out more about the process, and these are all on the slide if you want to get this down. You can attend the public hearing and share oral comments on the permit application on August 19th at 6 p.m. Eastern. And finally, written comments on the project are due on or before August 29th. And if you want to get specific links and more details about how to participate in person or online, we will be pushing out more information via our e-news and social media, and you can get on those lists or follow us by going to flowwateradvocates.org. In the coming months, we anticipate that EGLE will host another public comment period on the Clean Water Act Section 401 permit. This is also called a NPDES permit, the National Pollutant Discharge Elimination System. These are the Clean Water Act discharge permits. This is for the project's various wastewater discharges during both construction and operation. It is projected to continue to discharge. And Beth Wallace from National Wildlife Federation will be providing more information at the end of the program on how to craft strong comments and make the most of the few minutes you get in these public comment events. The draft environmental impact statement came out just this summer from the U.S. Army Corps of Engineers. In June 2025, thousands of citizens, tribes, and environmental organizations submitted comments to the Army Corps on this massively deficient draft EIS. It was rushed to completion in late May to satisfy President Trump's edict that federal environmental reviews of energy projects must be expedited to meet the phony energy emergency Trump declared in January. Flow Water Advocates submitted detailed comments on behalf of itself, the Sierra Club's National Environmental Law Program, and the Surfrider Foundation. The commenters criticized the Corps for wrongly narrowing the scope of environmental review to eliminate consideration of any alternatives that don't assume continued oil transit beneath the Straits of Mackinac. The comments drafted by Flow also focused heavily on the potential disaster from the likely impacts of tunneling in and pumping crude through 3.5 miles of fractured water-bearing rock formations beneath Lake Michigan that have been inadequately studied by Enbridge, the Corps, and their consultants. The Corps could release the final EIS this fall, followed by a decision 30 days later at the soonest on Enbridge's federal permit applications. Our next speaker, Skip Pruss, former director of the Michigan Department of Energy, Labor, and Economic Growth, will discuss more about these technical concerns with the draft EIS. I'd like to show you where we are in the NEPA process, this graphic. To spell it out just a little more clearly, we're nearing the end of a years-long environmental impact statement process under the National Environmental Policy Act. Most opportunities for public involvement have ended. And if the final EIS doesn't fully comply with the law, it is subject to judicial review. It can be challenged in court. And finally, I want to encourage you again, everyone listening, to follow Line 5 news and public comment opportunities through our e-newsletter and social media. You can also donate to support the vital work we're doing every day at Flow Water Advocates. Your support and involvement are critical to the fight and also just so encouraging as we work on this day after day, year after year. Your support really means a lot. Now let's hear from Skip.
Before we turn it over to Skip, actually, we just had one question come through that I think would be great to hear Carrie and Riyaz's thoughts on. So someone wants to know if there's anything that the public can do to encourage the judges or engage with the court to prioritize these cases, or if not through the judicial process, if there's other ways of supporting this, in particular, litigation advocacy that's going on.
Well, there's some very well-structured rules in place about contact with the court, contact with the judges for good reason. So the attorneys have been submitting amicus briefs, putting arguments in front of the court to support the parties that are litigating, and in addition to our own briefing. So it's supporting those legal efforts that is the most direct way to speak to the court and let it know that there is a strong public voice out there seeking to be heard. What would you say, Riyaz?
I agree with all that, and I would just add that I think both judges who now have the existing pipeline cases in front of them, Judge Jamo in the state court, Judge Yonker in the federal court, I think they both actually do really understand the significance of this case and the priority it deserves. The problems kind of preceded or were adjacent to them with other courts and the back and forth between federal and state court, but the actual decision makers now, they're both very good judges and they understand the significance.
I agree. I think we've drawn a very strong judges in this case, and we argue our best and hope for a good outcome. But I don't have any sense of I am not discouraged by the courts that we're in front of in Michigan. That's my area of specialty.
And I'll just say it's a great question, and there I see a bunch of other great questions in the queue. So hopefully we'll have a chance to get to some of them, or we'll figure out other ways to answer them.
Absolutely, thank you both. All right, so now I'll turn it over to Skip to talk a little bit more about the problems with the proposed tunnel project and what potential alternatives we might have. So thanks so much, Skip.
Thank you, Casey, and welcome everybody. If you are on this webinar, you are keenly aware that Line 5 crosses the Straits of Mackinac, the very heart of the Great Lakes. the largest and most valuable fresh surface water system in the world. You can also appreciate the economic and environmental consequences that would ensue if Line 5 failed. We all know that the 72-year-old pipelines are bruised, they're battered, they've been dented, they've been struck by anchors and pulled by cables. And we're really, frankly, very fortunate that an anchor fluke hasn't caught a pipeline in the past and severed the pipelines, resulting in disaster. So construction of a tunnel to enclose a new pipeline and protect it is not on its face unreasonable, though there are much better alternatives to Line 5 at all, and more on that later. So how did the tunnel project materialize? Well, at the end of the Rick Snyder administration, at the very end of 2018, the state of Michigan entered into 3 contracts with Enbridge, not Enbridge, the parent company, but Enbridge's subsidiaries, 3 of their 275 subsidiaries. At the same time, the legislature enacted legislation that created the Mackinac Straits Corridor Authority. Under these agreements, Enbridge would build the tunnel. Once completed, the Mackinac Straits Corridor Authority would own the tunnel. Enbridge would be responsible for operation and maintenance, and the state would be responsible in perpetuity for oversight of the entire operation. In agreeing to all this, the state relied on an analysis by a company called Dynamic Risk Assessment Systems that looked at all of the alternatives for dealing with Line 5, and Dynamic Risk recommended the tunnel based upon critical assumptions that did not hold. In fact, they have proved to be untrue in virtually every particular aspect. First slide, please. Thank you. So the construction of a tunnel bored underwater represents one of the most complex and high-risk activities in civil engineering, particularly in unpredictable geological conditions. To understand these conditions, you have to do a geotechnical investigation, which Enbridge did. It involved placing a drilling rig on the barge, passing the drilling rig through the water column of the Straits of Mackinac, and then taking core samples of the rock through which the tunnel would be built. Next slide, please. Constructing the tunnel entails the use of a tunnel boring machine built at considerable cost to bore through the geological formations well below the bottomlands of the Straits. The rock core samples that were developed indicate the kind of conditions the tunnel boring machine would encounter. The tunnel boring machine then must be designed to deal and meet those conditions. This is where the erroneous assumptions begin. The first assumption was that there would be a complete and thorough investigation of the geological formations through which the tunnel would be bored. The most frequently reported cause of tunnel collapse is unpredicted geology. Through 2021, there were 321 tunnel collapses documented worldwide, with 92% of them occurring in the construction phase, mostly due to encountering adverse geological conditions. To review the adequacy of Enbridge's geotechnical investigation, the state hired a firm called McMillan Jacobs. They are a global infrastructure engineering consultancy. McMillan Jacobs authored 3 technical reports evaluating the Enbridge geotechnical investigation, all of which found the geotechnical investigation to be limited, incomplete, and inadequate. These are not my words. The McMillan Jacobs stated that Enbridge, quote, did not adequately characterize the anticipated ground conditions of the site. There were an inadequate number of borings, far less than industry standards require. Most of the core samples were taken from an area above the tunnel pathway and didn't penetrate to the area where the actual tunnel would be built. Remarkably, there was only one data point from only one core sample from the deepest, most critical 2-mile section of the proposed tunnel route. The Army Corps of Engineers had to state ultimately in their draft environmental impact statement, quote, conditions along several portions of this alignment are currently unknown. So contrary to the assumptions of doing a thorough and complete geotechnical investigation, that clearly was not done. The second assumption that proved to be erroneous was that the tunnel would be bored through entirely sound and solid bedrock. The sampling that was done by the Enbridge investigation showed that the rock was highly fractured and permeable. Could we have the third slide up, please? So geologists use something called a rock quality designation system, and it's on a 0 to 100 scale, with the worst rock being 0. And 25% of the samples gathered by Enbridge's investigation were 0. More than 70% of the samples taken were either poor or very poor. In fact, the geotechnical investigation encountered 10 voids. These are open areas in the rock formation where limestone or karst has actually dissolved, leaving an open space. And the McMillan-Jacobs report said that since 10 voids were encountered in this limited, inadequate investigation, the tunnel boring machine would likely encounter many more. One of our experts, geologists, opined that what we see is not bedrock, what we see is geological pudding. The fourth assumption was that there would be minimal groundwater inflow and minimal groundwater pressure. We know now, and it is well established, that this project may encounter the highest groundwater pressure ever found in a tunnel construction project worldwide. There is a predicted calculation of encountering 16.8 atmospheres of pressure. And the McMillan-Jacobs report found that the hydraulic tests that were conducted by Enbridge's consultant were either absent or they tested the area that would be well above the tunnel path. Despite that, it is calculated that approximately 25,000 gallons of water, groundwater, would infiltrate the completed tunnel, and that would necessitate perpetual pumping and treatment of that water and perpetual state oversight of that entire process. McMillan-Jacobs concluded that, quote, there was significant risk that impacting tunnel operations due to the high groundwater inflows. And by some of the experts' opinions suggest that 25,000 gallons could be actually a magnitude higher. And so in the worst case, this tunneling exercise could have a blowout or a tunnel collapse that could even undermine the operation of the existing pipelines. The fourth erroneous assumption would be that there would be no methane or toxic gas encountered. Methane gas was detected. The Army Corps of Engineers indicated that infiltrating groundwater can be, quote, laden, unquote, with gases. And this tunnel is going to be bored directly above the Collingwood Utica shale oil and gas formation, which is capable of yielding gas and oil in recoverable quantities. Finally, the fifth erroneous assumption, and the most important, is that dynamic risk was thought that the tunnel would be filled with concrete to permanently seal the pipeline, preventing against damage and leaks. At that time, the tunnel was supposed to be 10 feet in diameter and actually filled with concrete. The concrete would encapsulate the pipeline, the new pipeline, really minimizing the potential for leaks or the accumulation of explosive gases. But the pipeline that is going to be built or is proposed is 21 feet in diameter, fully exposed, with a much higher potential for leaks and the accumulated gases from the infiltrating groundwater that we know would occur. So Michigan, unfortunately, has experienced tunnel construction projects that have resulted in catastrophe. In 1971, there was a tunnel boring project in Lake Huron. Methane gas accumulated, there was a spark, there was an explosion, and 22 workers died. More recently, in 2003, at the Detroit River Outfall #2 project, a tunnel boring machine was abandoned, actually, after water inflows overwhelmed the project and there was the dangerous presence of hydrogen sulfide gas. In that project, they encountered 5 atmospheres of pressure. Recall that I stated earlier that there will be almost 17 atmospheres of pressure in this project. The bottom line is that there is significant risk that the tunnel project will fail in its construction phase. It can be overwhelmed by pressurized groundwater and toxic and explosive gases. The tunnel boring machine can get stuck or break down, and it will encounter voids that may be too large to actually be filled and proceed. So you may ask, how can a tunnel project proceed when the state's own consultants have raised so many red flags? Well, the answer to that question or exploration of that question further, you could find on Flow's website if you go to the comments that the extensive comments that Flow has filed with the Army Corps of Engineers. If this tunnel project goes forward and fails, we will have additional years of Line 5 operating in the most vulnerable location in the Great Lakes. But that should not be the case because Line 5 is not necessary and Enbridge does not need Line 5. And for that, let me turn it over back to Riyaz.
Thanks, Skip. I'll try to be really quick here. I'm going to distill a lot into a short, but we have done a tremendous amount of work, we meaning our coalition altogether, on the economics of Line 5. This was a very central issue at the Bad River trial. The bottom line is that even if we are hell-bent on using every drop of oil that is currently transported by Line 5, replicating that oil supply, burning our world down, even if we want to do that, we can't. There's several simple steps that the marketplace would take in the event of a Line 5 shutdown to replace both the supply of crude oil and of propane. The market is, in fact, already adjusting in some significant ways, especially with respect to propane supply. As much as Enbridge likes to blow up the issue of propane in the Upper Peninsula, their own expert at our trial testified that simply the addition of a few transloaders would take care of the issue at a very small cost. This Governor's Upper Peninsula Energy Task Force called for the same thing. That's actually happening, and there have been other propane lines built. So that is not, that's simply not a major issue. Most of the upper part of the Midwest receives propane from sources other than pipelines and other than Line 5. That's what would take place here. On the crude oil front, Enbridge itself could actually take a few simple steps that would take care of all the crude oil that is supplied in this area. It has steadfastly refused to do so because it's not in its interest, but it has about 100,000 barrels of spare capacity on its Line 78, which supplies the same refineries as Line 5. It has also repeatedly told the state of Michigan that simply by adding pumping capacity, not new pipelines, but just pumping capacity, it could actually get that up to about 250,000 barrels, which is more than half of Line 5's supply. It hasn't done so because it's not in its pecuniary interest. It wants to maintain that capacity plus Line 5. It told the court, the Bad River court, that it couldn't do that because the lines that come from the north and feed Line 78 are purportedly full. That is just simply not true. Its own experts said it wasn't true. And very recently, Enbridge talked about expansion plans where it wants to take its pipelines that go from Chicago south to the Gulf and expand that capacity, expand its export capacity. Those are fed by those same north-south lines. So Enbridge's own business plans belie its claims. The other portion of the crude oil, which is largely that supplies the Quebec refineries, those refineries are all easily capable of taking oil by tanker from the St. Lawrence Seaway. They already do that. They could go back to doing that fully. They've said that. So the claims largely by Government of Canada and Enbridge that Western civilization would come to an end if you shut down the pipeline simply are not true. And the last thing I'll say on that is there's a lot of talk in Canada about independence from the U.S. There's a lot of talk in Canada about moving towards a more climate-friendly approach. Canada could do a lot of things itself, but in our current state of affairs, we bear all the environmental burden for supplying oil that is largely for Canadian purposes. And with that, I'll turn it back to you, Casey.
Thank you so much, Riyaz and Skip, both for unpacking that really important information. And you'll see in the chat, we have additional information for you on the tunnel as well as more on our website. So I know in the interest of time, we're running short. I want to make sure that we hear from Beth. Beth's going to talk about how we can get involved, what you can do to support these efforts moving forward. So take it away, Beth.
Thank you so much, and it's such an honor to be here with everybody. My name is Beth Wallace, and I'm the Climate and Energy Director for the Office of National Wildlife Federation in the Great Lakes. And I also co-direct the Great Lakes Business Network, helping businesses to engage in this issue as well. And I'm going to breeze through my presentation, and a lot of what I'm going to cover is going to be important information that I think will be helpful in the comment period, and runs through the history of this company and why we need to be pressuring state officials to be so much more critical, as so many of the other presenters have outlined. So I'm going to start with the 2010 Enbridge oil spill, because that is where I actually got my footing on this issue. I am from the area that was impacted, and worked really hard following that spill to try to apply lessons learned. But as you'll see throughout my presentation, we have, in some cases, actually taken many steps back because of the power that Enbridge holds across our country, and especially in our states. So I want to start off by just level setting. So in 2010, we had one of the largest inland oil spills in U.S. history when Line 6B, now called Line 78, burst, and a 6-foot gash in the pipeline went unnoticed by Enbridge for 17 hours. A local utility actually had to tell them that they had a rupture in the pipeline. And that pipeline ended up, is 15 years younger than Line 5. 40 miles of the Kalamazoo River were ultimately destroyed because of this product, which was a tar sands product. We didn't know how to clean it up, and it took Enbridge years. And there's still huge pockets of oil remaining in the river system in wetland areas because the heavy thick tar sands oil is nearly impossible to get out. And I'll just note that the Kalamazoo River is an extremely closed system. And so as I talk about some of these things, consider how impossible it would be to contain any type of spill in the Straits of Mackinac. But this particular spill sickened over hundreds of people in the area living along the river. It also caused over 150 families to flee their homes. Ultimately, water was cut off, and then thousands of wildlife lost their lives because of the spill. Thousands of wildlife was oiled. And then we have many lessons learned from this disaster that I'm going to walk through that have sadly either been not applied or upended in recent years through different actions Enbridge is taking. So almost immediately following that spill, the federal oversight dubbed Enbridge as having a culture of deviance. We've heard that already today. And they acted as the keystone cops for the spill. They were unprepared. And it was not only the lead up to the spill what caused the disaster, their lack of seeing that there was a rupture occurring, but it was also the behavior following. One example is they tried to get residents to waive their liability because in exchange for air purifiers and water, things that the citizens desperately needed in that moment as the toxic fumes in water were traveling through communities. We then went on to Enbridge, realizing that they had to really put on some political pressure and influence within the region because of how bad that disaster was. And that started immediately. Almost a couple of years after that event, the current Congressman Mark Schauer at that time was upended, and the former congressman for that district, Wahlberg, was put back in his place in support of Enbridge. And since then, we have seen a series of behaviors from that congressman that really upholds Enbridge and advances their interests over the interests of people, despite the really hard, incredible lessons learned that we had from that disaster. And then that influence has carried through, where Enbridge has tried to influence their gubernatorial races, and then their influence, Enbridge's influence, that ultimately created the Snyder Tunnel deal, which Skip already mentioned. And then that continues to this very moment where members of Congress are now trying to uphold Enbridge's interests and really take an already awful situation where we don't have policy and regulations that shut down aging infrastructure that is a high risk. And they're trying to permanently make it so that we cannot take actions to shut down Line 5, knowing that we have real credible reasons in doing so. And then we started to have Enbridge start to weaken and rewrite permitting laws. We saw that with the rebuild of Line 6B into Line 78, where they really abused landowners and expedited that process to go through very fast under emergency orders, similar to what we're experiencing with the tunnel now, where they have this false idea of there being an emergency to expedite and cut permitting review and the risk of the review of harm and risk. We also have the Snyder Line 5 tunnel scheme, which Skip already touched on, but it's important to note that they made that scheme and they solidified the future of the tunnel right after Governor Whitmer was elected during the lame duck and mere days before she was going to be taking office with the promise of taking action to protect the Great Lakes from Line 5. We also had Enbridge really divulging, we've heard this today in disinformation campaigns, talking about how Line 5 is a safe pipeline and they're going to be making it safer, and how we absolutely need this pipeline, which is not true. We already heard from Riyaz that there have been multiple experts that have been required under oath in courtrooms to break down how we can transition away from Line 5, which is ultimately why in the Bad River Band case, there is an effort to shut down Line 5 by 2026 through court order. We also had real big violations from Enbridge that showed that their behavior since the 2010 spill has not changed, and the construction violations for the Line 3 rebuild are a real problem and a real risk that the state of Michigan officials have to pay attention to and have to heed. And the fact that we are considering a tunnel without considering the actual construction, blasting, and drilling of the physical tunnel under the lake bed of the Straits of Mackinac is appalling. Especially knowing that the criminal behavior that they've had in more recent construction efforts. We also have real legal attacks on sovereignty and public trust, as we've already heard today. Those continue and they take different forms. So it's not just one way that Enbridge is attacking the Bad River Band sovereignty. They're also waging appeals and legal attacks against the Bay Mills Indian community and others to really weaken sovereignty and land protection rights, both for the state and tribal. And then similarly, we have a company that has gone to extreme tactics to monitor and interfere with tribal governments, tribal decisions, community engagement, and really influence and try to divide the communities in order to proceed with their projects. A very clear tactic that we've seen from other really intrusive industries in the past and toxic industries in the past, like big tobacco. And then also we have such clear examples of how Enbridge continues to hide risk, hide harm, hide the real condition of their particular pipelines. And then they actually are defying court orders in multiple different ways, including right after a major dent to their pipeline after an anchor strike. It took court order from a judge in order for them to shut down, test their pipeline, and make sure that there was no damage that could cause problems. And so we continue to face this level of defiance throughout the years since the 2010 spill. And then Enbridge covered up and tried to hide some of the damage that we know is not only like past issues with Line 5, but this is ongoing damage. The coating damage on Line 5 is consistent and it is ongoing. Enbridge is going to have to continue to fix that for the 5 to 6 years that they continue to let Line 5 operate while they're considering the possibility of a tunnel, and potentially indefinitely if the tunnel project completely falls apart, fails, or any of the core actions that have taken have continued to have delays. And so this coding issue is not just something that we had in the past. This is an ongoing consecutive issue, along with the lack of supports that remain for this pipeline. And then additionally, since the 2010 spill, we know that Enbridge has gone out of their way to not adhere to court orders and consent decrees that require them to look closer at their pipelines and try to get ahead of problems that could cause similar disasters to the 2010 spill. For that consent decree, they've had multiple violations with millions of dollars of fines specific to their inaction on Line 5 and applying the required testing procedures in order to ensure that we don't have immediate risks with Line 5. And we also know that the actions of Line 5, sorry, just a second, I have to move my screen. Spills are going unreported and undetected in Wisconsin. They had a pretty large spill that one of the largest spills that went undetected for months, and then the spill's quantity increased, and Enbridge had huge transparency all throughout, and this was just several years ago. And then additionally, we know that Line 5 has had upwards of 35 spills that we know of, over 1.2 million gallons spilled to date. And the alternatives that we're talking about really only cover small sections, and they are alternatives that only prolong the life of a pipeline that will continue to cause massive risks throughout its 640 miles. I will quickly run through this, but they continue to ignore water rights for the Bad River Band and other indigenous nations that are challenging the alternatives. They are also in really in the align with their culture. They have proposed a reroute for the Bad River Band that really does shift complete harm and risk and opens it up in a lot of ways into the headwaters of the Bad River Band, which these two images portray, which outlines how this company is not moving in a direction that upholds tribal sovereignty, upholds public communities and our interests and our water protection. They're making these actions in order to try to only prolong the life of Line 5 and to create division and controversy around the conversation, which muddies the water, as we're all seeing with a lot of their successful campaigns. And then the last few points that I'll make is that the tribal sovereignty piece is a massive issue where Enbridge is not only going after tribal water rights and their right to protect them, but they're also completely ignoring massive safety issues. And the federal agency, PHMSA, that oversees Enbridge, is also completely ignoring major safety issues. And in this administration, we know that huge rollbacks are being made, not only to policies and procedures that protect our land and water, but also to oversight and how we monitor these particular pipelines and who makes the decisions and when they make the decisions. And so these emergencies and these problems that we know exist today on Line 5 are only going to get worse. And really none of the solutions that Enbridge has proposed mitigate from those. And I'm going to skip to the very end because I know we're finished with time here, but please look out for NGO action alerts and attend local events and hearings. We already heard from Carrie the events dates or the hearing dates. So join the mailing list for Oil and Water Don't Mix, for Flow, for Earth Justice, so that you can be looped into not only those actions that are coming up, but you're also receiving communications on how to speak to some of these issues. And then support the legal efforts. I think there's some things being dropped in chat to talk about how to support the legal efforts. Contact your members of Congress. As I noted, we have some unfavorable members of Congress that are really lifting up the interests of Enbridge, and we need to breach even the members in Illinois, Wisconsin. So please reach out to all of your members of Congress and deliver some of the facts that we've delivered today. And then I want to say for the Eagle permits, something that's really important to note, that even if you aren't in Michigan, you can make comments to the Eagle permits because they take comments from all states that touch the Great Lakes. And so we really encourage out-of-state folks to also make their voice heard. And then please host a couple screenings and tell your friends and family of the things that they can do to take action. Appreciate the time.
Thanks so much, Beth, and thank you all again for taking the time to be with us. I know we're running up on the end of our lunch hour, so I want to just really quickly run through a last final couple points, but if you have to hop off, please know again that this is recorded and you'll have access to this and other resources in about a week or so. So again, thank you so much for your thoughtful questions. I wish we had more time to get to all of them, and we're going to be taking note of them and incorporating them into our communications and events moving forward. So thank you so much for that. I also want to give a special thanks to our amazing panelists for sharing their expertise on this matter. It's definitely inspiring, I think, for all of us to hear both the great work that's going on and also opportunities for each of us to contribute in our own ways. Another huge thank you to the Mackinac Island Community Foundation and the Straits Area Community Foundation who make this webinar possible. Thank you, thank you. Like I said, we're going to follow up with more resources and information. Just to echo Beth's important point, there's a lot going on. If you've taken anything away from this webinar, I think it's probably that. And so if you can get on our newsletters, and email lists of our partners in this work, that's the best way to keep up to date on everything going on. And we'll provide more information and resources on what you can do to help. I also have one small favor to ask. If you have the time, please take the brief survey that will pop up at the end of this webinar. We really appreciate your feedback. That'll also come via email if you don't have time right now. It helps us to make this programming better in the future. And with that, I want to thank you again for attending and taking action. Collectively, our voices matter in this fight to protect the Great Lakes. And it's not over yet. So I hope you come away from this event feeling energized, more knowledgeable, and empowered to join us in this fight. So thank you again to everyone, and hopefully we'll see you again soon.